order this morning. Excuse me. I hereby call to order this morning's 15th meeting of the Public Utility Commission for calendar year 2013 and ask that you join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The first item on this morning's agenda is the approval of the minutes of the August 29th public meeting, and I'd like to recognize Commissioner Cawley as editor of the minutes. Commissioner Cawley.
Thank you, Chairman. I have reviewed the minutes of our August 29th public meeting, and I move that they be approved as submitted.
Second. Any discussion? Any objections? Hearing none, the minutes are approved as submitted. It's a pleasure to welcome to the podium this morning to begin public meeting Ms. Cheryl Walker-Davis. Good morning, Cheryl.
Good morning, Mr. Chairman. Good morning, Commissioners.
Good morning.
May it please this honorable commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Bureau of Audits. It is recommended that the commission adopt the two items appearing on page 1 through and including the recommendation to make public the Section 516 audit reports with regard to management audits and management efficiency investigations concluded during fiscal year June 30, 2013.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Office of Special Assistance, it is recommended that the Commission adopt the first three items, consisting of the first two items on page 2 through and including the complaint proceeding involving Deidre Alston versus National Fuel Gas Company on page 3.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
With regard to Williamtown versus the Great American Power LLC, there is your joint motion, Mr. Chairman, with Commissioner Whitmer.
I'd like to recognize Commissioner Whitmer for purposes of our joint motion.
Thank you, Mr. Chairman, and I would like our joint motion to be entered into the record as if I had read it in its entirety. Before the Public Utility Commission today are the exceptions of Williamtown to the initial decision addressing his formal complaint against Great American Power, a licensed electric generation supplier. In his complaint, Mr. Town alleged that he was contacted by telephone 14 times in 26 days in an attempt to switch his electricity supplier from Duquesne to Great American Power, and that the marketing techniques used during this time period were misleading and confusing for customers. The administrative law judge sustained the complaint in part and assessed a civil penalty of $5,000 upon Great American Power. We agree with the Office of Special Assistant's proposed recommendation to deny most of the complainant's exceptions. We also agree, though, with the complainant's exception number 20, that the civil penalty amount of $5,000 assessed against Great American Power is insufficient given Great American Power's conduct. In this case, it is factually undisputed that Great American Power contacted Mr. Town 14 times over a 26-day period, despite repeated requests by the complainant to stop. The ALJ stated that the complainant, and no doubt other customers in the Duquesne Light Service Territory, were subjected to numerous phone calls by aggressive sales representatives using potentially misleading statements that at the very least created a substantial risk that the consumer would not understand who was calling and that they were enrolling in an electric supply agreement that they would have to opt out of rather than affirmatively consenting to choose Great American Power as their independent supplier. Therefore, based on the evidentiary record in this proceeding, we recommend the Commission raise the civil penalty against Great American Power to $10,000. We find the conduct by Great American Power not only troubling, but potentially detrimental to the ongoing enhancement and the ultimate success of Pennsylvania's electric retail market. As we have stated in prior cases, we strongly believe the competitive market can provide consumers with a variety of products and services, and that consumers do bear some responsibility to choose a product that is appropriate for their individual circumstances. However, for those market forces to work, this Commission must continue to send a clear message to EGSs that the egregious and deliberate behavior utilized in this case, including the use of potentially misleading statements, could result in slamming and are not going to be tolerated. Furthermore, in cases where the Commission believes that EGSs need increased oversight to ensure adequate compliance with our regulations and statutes, the Commission has imposed conditions upon suppliers' EGS licenses, and we recommend imposing conditions in this case. Finally, and as the initial decision has made clear, there is the potential that other customers were subjected to similar mistreatment by Great American Power, as experienced by Mr. Town. As such, we recommend referring the case to the Commission's Bureau of Investigation and Enforcement for further action as may be warranted. Therefore, we move that the civil penalty assessed in this case against Great American Power be increased from $5,000 to $10,000. Great American Power's ability to offer, render, furnish, or supply electric generation supplier services is subjected to conditions noted below, which will apply for a term of 18 months from the date of the entry of the order. The Commission's Bureau of Technical Utility Services, with assistance from the Bureau of Consumer Services and the Law Bureau, shall monitor Great American Power's compliance with conditions set forth in the motion. Also, upon receipt of the status report directed in paragraph 2 above, that the Bureau of Technical Utility Services, with assistance from BCS and the Law Bureau, prepare a staff recommendation regarding appropriate license conditions after the expiration of the term, which will be considered at a future public meeting. That this case be referred to BI&E for further action as may be warranted, and that the Office of Special Assistants prepare an opinion and order consistent with this motion.
Second.
Mr. Chairman.
Thank you, Commissioner Whitmer. We have a second from the Vice Chairman. Any discussion?
Chairman, may I join in your motion and particularly join in increasing the fine? It's unfortunate that we have an occasional bad apple in the barrel when we have literally dozens upon dozens of electric generation suppliers who are acting within the law and who treat customers the way they deserve, with courtesy and certainly not in the manner that this electric generation supplier treated Mr. Town. Since this public meeting is the very first in which we are streaming our public meetings to the internet, I would like to use this occasion to encourage the public to tell us if they are similarly treated. I don't think this happens very often, but we depend on the public, like Mr. Town, to tell us when an electric generation supplier, or for that matter, a public utility, steps out of line. So with that, I congratulate you two on this motion. It's entirely appropriate under the circumstances.
Thank you, Commissioner Cawley. Any further discussion? Hearing none, the joint motion passes unanimously.
Continuing with the presentation of agenda items on behalf of the Office of Special Assistants, it is recommended in omnibus fashion that the Commission adopt all items appearing on pages 4, 5, and 6 through and including the recommendation pertaining to the complaint proceeding involving Thomas and Marjorie McCary versus Pico Energy Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Bureau of Technical Utility Services and matters commencing on page 7, it is recommended that the Commission adopt the recommendation pertaining to the application of Palmco Energy PA LLC.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
With regard to the affiliated interest agreement between the PPL Electric Utilities Corp. And Kentucky Utilities Company, there is the motion of Vice Chairman Coleman and the statement of Commissioner Gardner.
I'd like to recognize Vice Chairman Coleman for purposes of his motion. Vice Chairman.
Thank you, Chairman. I'd ask that my motion be entered into the record as though I read it in its entirety. Before the Commission for disposition is the affiliated interest agreement between PPL and Kentucky Utilities Company, which is a public utility organized under Kentucky and Virginia law and doing business in Virginia as Old Dominion Power Company. The agreement would allow the companies to provide emergency assistance to each other when service has been disrupted due to weather, equipment malfunction, accident, sabotage, or other occurrences for which emergency assistance is necessary or advisable. The agreement stipulates that the company requesting assistance will pay all costs and expenses incurred by the responding party in furnishing the emergency assistance. Under Section 2B of the agreement, these costs and expenses include, but are not limited to, 1, employee wages and salaries, employee travel and living expenses, replacement of cost and materials and supplies, repair or replacement cost of damaged or lost equipment, charges at rates used internally by the responding company for the use of transportation equipment and other equipment, and 6, the administrative and general costs which are properly allocated to the emergency assistance. PPL asserts that it will pay only the actual cost incurred for emergency assistance. PPL adds that the above language on cost responsibility was taken directly from the principles governing cost and expenses from the Edison Electric Institute's suggested governing principles covering emergency arrangements between Edison Electric Institute member companies. PPL is required to obtain commission approval for all the agreement in accordance with Chapter 21 of the Public Utility Code, and I believe that the agreement is reasonable and in the public interest and should be approved. The agreement provides PPL with access to an important resource, that is mutual aid, with electric service to customers that has been disrupted due to, among other things, extreme weather events. The mutual aid available under the agreement is critical to ensuring that service is restored to affected customers as quickly and as safely as possible. I find the language in Section 2B of the agreement regarding cost responsibility to be reasonable as well. I don't believe that this language is vague or overly broad, as Section 2B contains what is a comprehensive list of specific emergency-related assistance costs for which PPL may be responsible under the agreement. I also do not believe that the agreement puts PPL customers at risk for bearing the burden financially or any unreasonable emergency assistance-related costs paid by PPL under the agreement. I remind the parties today that the decision is not a determination of cost recovery for ratepayers or the reasonableness of any cost for emergency assistance paid by PPL under the agreement, but rather the rate-making treatment, if any, for these costs is reviewable in a future rate-making proceeding where PPL requests cost recovery for such expenses. To the extent PPL seeks recovery of the costs not specifically identified under the not limited to clause of Section 2B of the agreement, PPL should explicitly describe the nature of these costs and expenses and should provide a specific amount of such costs and expenses. This should provide statutory advocates and other interested parties of the Commission the opportunity to conduct a detailed review prior to allowing any cost recovery. Therefore, I move the affiliated interest agreement between PPL Electric Utilities Corporation and the Kentucky Utilities Company, Old Dominion Power Company, be approved consistent with this motion, and that the Commission's Bureau of Technical Utility Service prepare an appropriate order consistent with this motion.
Second.
I'd like to recognize Commissioner Gardner for purposes of his statement. Commissioner Gardner.
I support the motion.
So noted. Are there any objections? Hearing none, the motion passes unanimously.
Continuing with the presentation of agenda items, on behalf of the Bureau of Technical Utility Services in omnibus fashion, it is recommended that the Commission adopt the last item, Keep It Moving LLC, on the bottom of page 7, as well as all items appearing on pages 8, 9, 10, 11, 12, and 13 through and including the rate increase request involving Mill Creek Paramedic Service, Inc.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Law Bureau, again in omnibus fashion, we recommend the adoption of all of the items appearing on pages 14. On page 15, it should be noted that the first item pertaining to the rulemaking involving the implementation of the unconventional gas well impact fee has been postponed until public meeting of October the 17th. The omnibus continues with the remaining item on page 15, as well as the item on page 16 involving the policy statement pertaining to utility service, outage response, recovery, and public notification.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Office of Administrative Law Judge, we recommend the adoption of ALJ Salapa's recommended decision in the PPL Annual 1307E proceeding appearing on page 17.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Mr. Chairman and Commissioners, that concludes the presentation of regular agenda items. Turning now to the carry-in agenda. We recommend the adoption on behalf of the Office of Special Assistance of the recommendation pertaining to the settlement between the Bureau of Investigation and Enforcement and UGI Penn Natural regarding the gas safety issues occurring in Wilkes-Barre. And it should be noted that the recommendation should be modified to state that the Commission adopt the proposed opinion and order which approves the settlement.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Bureau of Technical Utility Services, we recommend the adoption of the recommendation pertaining to Specialized Moving Services, Inc.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Mr. Chairman and Commissioners, that concludes the presentation of agenda items.
Are there any other items to come before the commission?
No,
Hearing
Mr.
none, we
Chairman.
are adjourned.